So I'm going to kick it off. Here is the agenda. You can see that there's a lot to cover. Donna and I selected a mix of issues, a mix of statutes and cases. It's really a broad array of topics. Michelle, Martha, Andrea made us promise that this would not be a COVID-19 PPP loan presentation because we could spend the entire time on that. And I happen to agree with them. I don't want this to be that presentation. But with that in mind, I want to start with the PPP loans.
Michael, just your presentation isn't showing up. If you can make sure you share your screen.
Okay. I don't know. I'm so sorry.
That's okay.
Try this again. I thought it was.
There you go.
Okay. Sorry about that.
Thanks.
No problem. You know, I may have mentioned this. I'm sorry. I know we're quick for time, but again, we were talking about this beforehand. I have this weird aura, and it just throws off electronics. I like to think of it as my own personal animal magnetism, but it also seems to repel women, so it doesn't work so well for me. Anyway, okay, so we're going to start off by talking about the PPP loans. And I know a lot of schools are really thinking about it, deciding what to do with them. And I'm not planning on getting into the details of that. What I want you to know are really two things that I'm going to mention. One is that if you do take the loan, there's a series of federal laws that apply. They're listed on the slide. And I don't think it's a surprise to many of you that there are these federal laws that would apply. But I've gotten a couple of emails from schools over the last few days asking about it and saying they weren't sure and which ones would apply and what's required. So I just wanted to list those out. I would say that, you know, in my experience, speaking with schools, Title IX is the law that's causing the most concern. Understandably, with Title IX, you need to have policies, you need to have procedures, you need to have training. I think the other big concern about Title IX is that it's a very highly litigated area of the law. And so there's going to be some risk when you're covered by Title IX that I think you don't face otherwise. There's exceptions for religious schools, or at least some religious schools. There's exceptions for single gender schools. So Title IX, I think understandably so, is really the focus. Title VI is important. Age Discrimination Act is important. But I want to just take a moment to mention Section 504, which is a federal law that has to do with disability discrimination. And on the one hand, it's very much like the Americans with Disabilities Act, Title III, already applies to students for non-religious schools. But for religious schools, now you're going to be covered by Section 504. And even for secular schools, now there's a very well-worn path to litigation. It just gives another opportunity for there to be sued. So at least if you're taking the loans for the short time you're going to be covered by them, I really do think it's important to make sure you're aware of these laws, you're complying with the policies, procedures, and the training where it's required. And even if, by the way, I'll just say, even if you think, you know, this is not a big risk for us. I mean, you know, maybe you haven't heard, but there's a pandemic. We don't have kids at school. We don't have teachers at school. You know, we're going to only be covered by this for a short time. Why is this really something we should be concerned about? I might disagree with you, by the way, in terms of the concern you should have for it. But I will tell you that I'm also concerned about public relations kinds of issues. There have been, again, I don't think I'm telling people anything they don't already know, there have been a series of articles in the New York Times and LA Times and in others about schools and colleges taking these loans. And I think if you were ever asked about taking these loans, you would want to be able to say that you took your obligations seriously, that you adopted the policies that you needed, you did the training that was required. And so I think that's something that should not be overlooked as well. Okay, in terms of COVID-19, the other issue that we promised not to really spend a lot of time talking about, I just wanted to put in there, and Don and I went over this too, and Don, you should feel free to jump in if you like, a series of issues related to it that maybe you're thinking about, maybe you're not. I know that you're all so busy right now with so many things. There's absolute information overload. I think it's been incredibly impressive to see how schools manage to turn on a dime, go from the live teaching to something online. But here's a number of issues you may not be thinking of. I'm not going to read them all to you. I just want to mention a few. One is wage and hour. For exempt employees, I would say generally speaking, you shouldn't face many concerns with having people work remotely. But for non-exempt employees, for those employees that need to keep track of their time, get meal and rest breaks, I have a little more concern about that because it's harder to keep track. It's harder to know how many hours those non-exempt employees are working at home. If you don't have good records, that could be an issue down the line. The same with meal and rest breaks. Just because they're working remotely doesn't mean those requirements don't apply. So that's one part of it. In terms of telecommuting, I think a really interesting issue that we're going to have to think about in the future is going to have to do with reasonable accommodations. Because I think that schools have really taken it for granted, and I've certainly agreed with this, by the way, in the past, that for most positions, being on campus, being there in person is an essential function of the job. And I think coming out of this, as we think about the future, it may be a little more difficult to say to at least some employees that you have to be here, that you cannot perform your job remotely. Maybe that won't be true for teachers, for teaching assistants, but I think it may be true for others. Two more things I wanted to mention. One has to do with the local laws. It's the third bullet point from the bottom. It says complying with local, state, federal guidance. I'm starting to see schools think about that more when it comes to, for example, graduation. I've gotten a number of calls from schools asking, can we do this for graduation? Can we do that? It's not enough to follow the federal and state requirements, for example. You have to be very familiar with local requirements. That can differ by county, for sure. Can also differ by city. And so you really need to take a look at that. There was a really insightful, I thought, email that one of our partners, Brian Walter, sent, having to do with graduations and an idea a school had for getting people on campus. I won't go over the details, but he noted that the local guidance prohibited, first of all, groups of a certain size from gathering. And the second thing he noted was that you're really only supposed to come on campus if your purpose is to fulfill an essential duty. Graduation was not one of those. So I think there was some risk. I've also mentioned to a couple of schools when they've talked about graduation and having people there, I think there's a real risk of a negligence claim. And I think that's something to keep in mind too, by the way, for reopening in the fall. All of these guidance are going to be critically important when it comes to making a plan, hopefully for reopening. But one of the things I've mentioned is a negligence claim. If other schools are not opening, if other schools are not allowing people to come on campus, if somebody does come and gets sick or passes it on or takes it home and someone else there in their family gets ill, I think the school may be exposed to a negligence claim. And this is going to make ensuring that you're really following these guidance carefully really, really important. The last thing that I want to mention, which I think, by the way, is far more important than I think most schools realize, is antitrust. And let me tell you where I'm coming from on this. If you think that I'm being overly critical of, for example, the Cal-ISBOA listserv, I want you to know I'm not. I'm not actually even thinking of that listserv. I'll share with you that I belong to a listserv that attorneys who represent colleges and universities belong to. And that's monitored by an attorney for this organization. It's a great organization. And about a month ago, she sent out a warning to attorneys who are part of the listserv, reminding them that they might be violating antitrust laws with some of the questions they were posting, with some of the information they were requesting. And she reminded us that many years ago, there was a lawsuit and the postings on their listserv were subpoenaed, and told us to be careful about that. About the same time, I don't remember exactly, and you may know about this, the Federal Trade Commission and Department of, not the Department of Labor, the Justice Department, put out a joint statement warning employers about antitrust violations. If you read it, it was very interesting. They said basically, look, we know there's a pandemic. We know people are struggling to deal with it. We know that there's value in reaching out to others for guidance and to find out what's going on. But to the extent you're asking information about wages, for example, and other issues that could be seen as non-competitive, that's a violation of the law. And you're not permitted to do it simply because of the pandemic. And it was a real shot across the bow, I think, to employers to be careful in terms of what they were asking for. And so I just put this out there because I have some concern that understandably, people are worried about enrollment, about tuition, about refunds, about wages, about a lot of things. And if there's questions going out about what are you doing and what should you not be doing, I really think that there's some risk there of an antitrust violation. So I hope you'll keep that in mind. Okay, Donna is going to speak now about AB5 and some other issues.
Hi, everybody. We're so glad to be at the conference. I wish we were face-to-face and able to have our happy hours and those kinds of things. So we'll have to make up for it next year. I have my first slide here, and I can't put my picture up because it crashes my call, so I apologize for that. But we continue to bring you bad news in the area of independent contractor status. Many of you will recall we reported on a California Supreme Court decision in 2018 called the Dynamex case, which overturned the earlier Bolero test for independent contractor status. And what it did essentially was made it harder for people who provide services at your schools to qualify as independent contractors. So this bad news slide goes on to say that the state of California has now codified the ABC test that was established in the Dynamex case. I think the good news is down at the bottom bullet point there, it was supposed to be effective January 1st of 2020 this one did become effective on January 1st, 2020. And basically this test provides that someone who provides services at your school is presumed to be an employee. So that's where you start. The ABC test determines whether there is enough to put them into an independent contractor status. And the first element is whether they're free from the control and direction of the hiring entity. That's been in place for a long time, and that was the main factor under the Bolero test. But items B and C, you have to qualify for all three: performing work that is outside the usual course of the hiring entity's business. So if you have somebody who is engaged in teaching, it's going to be very, very hard to argue that that person is an independent contractor under this new test, even if they're part-time, even if they're teaching something that isn't part of your regular curriculum, even if they're a substitute. And so, we had this guidance from the Dynamex case. We've been following it. Item C, customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So if the person is engaged in the type of work that is related to schools, that's another factor that makes it harder to qualify as an independent contractor. And the state of California did not just adopt the Dynamex case, they actually expanded the scope by amending both the labor code and also the unemployment insurance code. So violations of this used to go to just to the Industrial Welfare Commissioner, but now you have, many more areas of the law that you could be violating if you violate this. And so there are ways to, to navigate this. That Labor Code Section 2750.3 actually does carve out exceptions. And, exceptions like attorneys and doctors and commercial fishermen. But some of the, I went through the list, and some of the titles that we see our schools having are on that list. HR administrators are on the list. So those folks that you do contract with for your HR services, some of you would qualify. Psychologists are on the list. Private investigators, when you have an investigation happening and you hire an outside investigator, they're on the list. Architects are on the list. But teachers and, a lot of the other kinds of services that you provide that involve students are not on the list. So that is now codified as state law and not subject to necessarily being changed by the next, Supreme Court decision. Any questions on that one?
Yeah, Donna, I don't know if you can see in the chat, there's a few questions that have gone out. I can read it if you want.
Sure.
Margaret Randazzo asked, can you expand your explanation on item C a bit more? Are you saying if person does work for other schools, ?
Yeah, so item C so basically the question that you ask is the individual that you're trying to establish is an independent contractor also are they engaged in an independently established trade, occupation, or business of the same work performed for your school? So for example, I think food service is a good example of a qualifying category, because you've got people who have a food service business. They come in and provide as independent contractors that service to your school, and they have a business that is a food service supply business. Janitorial services is another good example of that. But if they're just a part-time music teacher and they go from school to school as a music teacher and they don't really have a separate business that they can point to, then they would probably fail under item C. And you want to look at, our recommendation would be to have those folks be hired as employees. They can be very part-time, and if they are very part-time, you don't have some of the other benefits issues or overtime issues. Even if they don't qualify as exempt, they're still not going to be working overtime, so you're not going to have those risks. So that's what you want to look at in figuring that piece out.
And then there's also a bunch of questions about, musical performers, figure models, photography, kind of those one-off people that might come in for performances. We had several people kind of ask about that. Dance teachers.
Right. Almost always, if they're a teacher, they're not going to qualify as an independent contractor. But for example, photographers are on the list. If they are an independent photographer, so the person that comes in and does photographs for, your view books or, any of the materials for the school, who's not otherwise performing other services like teaching photography, would qualify likely as an independent contractor. It really does need to be analyzed on a case-by-case basis, because whether someone's an independent contractor can turn on you know, basically what you're asking them to do. So another element of this is you know, we don't just look at the contract, we look at what the person is actually doing. And so you have to have both of those pieces aligned with qualifying as an independent contractor.
And can I just jump in for 1 second?
Yeah.
Which is, because Don, I'm seeing the questions just explode with very specific examples. And to be honest with you, we don't have time to get into it. But I want to say two things. One is the example that the Supreme Court gave to show when somebody would not be an employee is if you are a retail establishment and you have to have a plumber come in and fix the bathroom. So that shows you how really, you know, unlike what you're doing, the person might have to be to qualify as an independent contractor. Second thing is that several of the questions, I think, I'm going to summarize as being like substitutes or being people who come in on maybe a very part-time basis. I don't think that you could get past B on the ABC test of performs work that is outside the usual course of hiring. By the way, even before this test, I don't think a substitute was an independent contractor. And I especially don't think you can do that now. So the questions that are coming up are really good ones. But like Donna said, for many of them, it would require, you know, a very, you know, specific analysis before I think we could say with confidence whether they would qualify or not.
Yeah, and we're happy to talk to you afterwards or answer emails if you've got questions about that. But the reality is a lot of schools are out of compliance with this because these laws are just not at all like the wage and hour laws, not at all written with schools in mind, and you have to comply with them, and it's a real challenge for all of our clients, the independent contractor piece, and it's just gotten worse is the bad news. So going on to, are we going to go on to the next slide here? This is another new law, AB 1548, which provides funding for nonprofits at risk due to ideology, beliefs, or missions. You know, the risk of being a victim of a hate crime or violent attack. The state of California was intending to appropriate $15 million for this account to provide support around the area of security guards, reinforced lighting, additional alarms. Some of you may know there's a federal program that's similar. This is a little bit different from the federal program in that it does allow the funds to be used on security guards where the federal program does not. It also increases the amount that is available per application, going up to $200,000. It's got the title of it is the California State Nonprofit Security Grant Program, and it's got a very long acronym. And folks who want to apply for that, it is administered through the Office of Emergency Services. But, you know, just wanting to raise the cautious note, this bill does not state how it works with Education Code Section 220. And that section prohibits discrimination by an educational institution that receives or benefits from financial assistance from the state. So this is another one where, you know, taking advantage of the benefit may create additional obligations, legal obligations for your school, and so you'd want to analyze that as part of deciding whether or not to take advantage of that program. Okay, going on to arbitration agreements. So this law, so AB 51 is sort of the continuing march of the state of California against arbitration, mandatory arbitration clauses in employment agreements. In this case, the law was supposed to go into effect at the beginning of the year. There is an order that granted first a temporary injunction and then a preliminary injunction against this going forward at this time. So this is one that we're going to be looping back to you as it develops. But basically, the state of California wants to be able to make it easy for employees to file complaints, especially discrimination and harassment complaints. And so they do not want there to be laws that make it harder to do that, or that make it hard to go to the Department of Fair Employment and Housing to administer a complaint because of arbitration clauses. When this law was passed, was signed, the U.S. Chamber of Commerce challenged the bill and claimed that it was preempted by the Federal Arbitration Act of 1925. And that is where the injunction has been issued. And basically, the judge had a good reason for approving the preliminary injunction. She said that if that wasn't done while this was being challenged, a whole bunch of employment agreements could end up being disrupted. And so that was a compelling reason to issue an injunction in this case. The Federal Arbitration Act has as one of its main purposes to promote the use of arbitration proceedings and the validity of arbitration. It also provides that arbitration agreements are contracts that must not be treated differently than other contracts. And in this case, we do have, AB 51 does treat arbitration agreements differently from other contracts. And so, the main point for our schools on this one is that the law every single year changes on arbitration agreements, and you really need to keep up with the language changes that are required by that in order to have your agreements remain valid, but also keep asking the question, are arbitration agreements doing what they did all those years ago when, being able to have a quicker process for less cost and better privacy was a better solution than going to court. And I think with all the restrictions that are being placed on arbitration agreements today, that's worth analyzing as you move forward. Okay, so there are no questions on that one. Going forward onto another bad news case on electronic signatures. So this is a case to really pay attention to. In this case, Renovate America provides financing to homeowners for home improvement projects. And this plaintiff contracted through them to provide solar panels for her home. That project did not go well, and she filed a complaint, and the company filed a motion to compel arbitration because its records indicated that she had signed an arbitration agreement as part of the contract. She stated she had not signed an arbitration agreement, and that she could go straight to court and not have to go to arbitration. And what the court stated in this case was that if a person asserts that their signature is not authentic, the burden falls on the person claiming that there was an authentic signature there to prove that it was an authentic signature. So in this case, Renovate used DocuSign, which I think most of us have used before, and they complied with DocuSign's process. DocuSign complied with their process. They made themselves available as witnesses in this case to explain their process and to go through the steps as to why this was a valid, authenticated signature. And the court said that was not enough. And so the first point that I think we want to make on this is, as you're working with vendors around electronic signatures, recognize that having a good vendor who has good practices in place and good policies in place is not necessarily going to be enough. And so you want to make sure that you are able, if there's a challenge to that, to authenticate a signature. And the court actually went through steps that you should take in order to demonstrate that you met the legal standard on authenticating an electronic signature. And I think there's like 5 of them that you want to be able to specify who sent the agreement to the particular person. So that's number 1. You have to specify how it was sent. You have to be able to describe and specify how the electronic signature was placed on the agreement. And then going further, how the signed agreement was returned and how the identification was verified. And so you want to make sure that either with internal electronic signature processes or in working with vendors on that, that you have a way of being able to demonstrate evidence as to these elements so that you are able to authenticate a signature if usually it's a parent says that they didn't sign it. And we do get a lot of questions over the year on this. I think in my experience, schools have good systems that have worked for most people most of the time. And, you know, it's hard to hear all of these steps that need to be taken because you're trying to save time and money and paper in having electronic signatures. It is still the case that a wet signature provides you with the best legal protection around authentication because that is, you know, clearly able to be authenticated, whereas there continue to be risks with the electronic signatures. Any questions on that one?
Donna, can I just add something? There's other questions I'll come to in a moment, but just on the issue of electronic signatures, as you know, Donna, we have litigated this a number of times, and one thing that I want to make sure is not lost is that the way this often comes up is a parent or, you know, who's taking issue with the enrollment agreement or an employee, they'll file a suit in court, and the school then has to basically object to that, and it has to file its objections within 30 days. And so there's not a lot of turnaround time, and often we have to reach out to DocuSign or Blackbaud or whoever the school is using. And it's not good when that's the first time the school's trying to figure out who to contact, how do we get what we need, do they actually comply with California law or do they just comply with federal law? And so I think that asking your vendor, if you use a vendor for this early is much better. I still get questions from schools, and I understand why. I mean, this is a technical issue with legal ramifications, and yeah, few people are expert in these kinds of technical issues. I still get questions about, well, you know, is it okay just to have them type their name? What if I have them click a box saying they agree? That's not sufficient given the criteria Donna just mentioned. And so it's something really important to be thinking through ahead of time.
Okay, and were there other, I'm sorry, I'm not seeing the questions. Were there other questions on that for right now? Okay. All right, so I think we can go on to the next slide. Just really quickly on this one, I know you've all heard of this, AB 218, which expanded the statute of limitations for claims of childhood sexual assault. And so the law previous to AB 218 was eight years after the age of majority or within 3 years that the individual discovers that their injury was due to childhood sexual abuse. And so there had been attempts to pass legislation like this over the years, and California finally did that. I think the main point that I would make about this is that, you know, we all read about the schools that have gone through this and the steps they take, and we get, you know, glean sort of some of the better practices and some of the other responses that perhaps were harder on the school. This is really an individual case-by-case approach on these cases. I mean, just, you know, in looking at, you know, in advising on these cases as they come in, you know, sometimes you have nobody at the school who was present when the assaults allegedly occurred. Sometimes you have lots of people at the schools, you know, when these complaints come in. You know, you're going to have very different steps, very different responses, very different issues to deal with, you know, with each of these kinds of complaints. They are, as much as they are a big, you know, category of childhood sexual assault cases involving schools, they are also very, very different, each and every one. So I think, you know, just hopefully we're seeing less of that going forward, but, you know, please know that there's, you know, and I think you all know that there's, you know, there's no sort of script for this, and, you know, just make sure you've got a well-coordinated team on deciding, especially around communications, around how you communicate, how you reach back, how you move forward. So I don't know, Michael, if you had anything else to say on that subject.
No, not on that. You did a great job. I don't have anything to add. I did want to go back, if that's okay, and answer a couple of questions that I saw were being asked. Unfortunately, there's not time to get into all of them. As Donna said, you can call or email us later. But I did want to address at least 3 questions that came up. So if it's okay, I'm going to just take a step back very quickly. So 2 of the questions had to do with Title IX. One of them was was who should be the Title IX coordinator, and the question was, should it be the HR person? And my answer to that is it can be the HR person. That's fine. I don't have any objection to that. Some schools have selected a dean, for example, if you have that at your school, to be the Title IX coordinator. The way that I look at it is it's a real professional development opportunity for somebody to learn about Title IX, to learn about best practices, to learn about policies and procedures that you may like, you may not, but maybe it's something you want to integrate with what you have or think about in the future. So it is worthwhile thinking of who the right person is, but those are the ones who come up. There was another question about, if we take the federal loans, how long are we covered? And I've gotten this question a lot, which is why I want to address it briefly. And I want to emphasize this. What we have so far is non-binding guidance. I've seen a lot of references to what I'm about to say as if it's a certainty. And I want to emphasize it's non-binding guidance that says the obligations under these federal laws last until the loan is either repaid or forgiven. And that's a reasonable position, by the way, and it's reasonable to rely, you know, to some extent on this non-binding guidance, but I just want you to know it's non-binding. And I think anybody, and by the way, you should disagree with me if you want, but I mean, the last couple of weeks, we've seen a lot of changes, a lot of movement, a lot of things happening here, and that could happen as well in terms of how long you're going to be covered by it. The other thing is that there's a Title IX regulation, an existing regulation, that says, and I'm summarizing it, but it says basically if you use federal funds to pay rent, then the federal laws might apply to you for the term of that rental agreement, which could really lengthen things out. So my sense is that most schools are spending the money on salary, which is, I think, a good argument for, you know, until you've repaid or forgiven. But if you're taking some of that money to pay rent or, you know, use it for something like that, I think there's a real risk Title IX could last longer. The other thing I wanted to mention, sorry, I'm seeing more other questions, but the other thing I wanted to mention was I've seen a couple of people ask questions about getting a waiver for COVID-19, saying if we have people back on campus, can we get a waiver? Sorry, I heard something. And I want to let you know that in my opinion, I do not think that's a good idea. And I'll tell you why. There's two main reasons. One is I don't think you can have a waiver for it. I mean, the law in California is that you cannot waive gross negligence. So I mentioned before the importance of following guidance. So if you're following, I'm making this up because I don't know, but if the guidance is you have to maintain social distancing, people have to wear masks, you know, take it from there, and you do all of it, then it seems to me, I'm hearing a noise, maybe I'm the only one. Then if you have something in your enrollment agreement or something, a general release of liability, if you want to put something, and if you don't have that, you should, by the way, already anyway, that would protect you. But, and I think this is obvious, if you had people sign a waiver and they came back and you were hugging them, kissing them, said, you know what, we're not going to worry about masks, these are kids, we're going to let them play contact sports, you signed a waiver, we don't have to worry about it, that would not be enforceable. I've heard a couple of people raise the possibility that the state or the federal government would pass a law saying employers could not be liable for COVID-19 related claims. We'll see if that happens, but without that, you know, I think somebody could bring a claim. The second reason why I think it's not a good idea is that I don't think that's going to give parents a lot of confidence in the school. I mean, it doesn't strike me as a good idea to send something to parents saying, hey, we're excited to have everybody come back, sign this form, agreeing that if anybody gets sick, we're not responsible for it. And what are you going to do if they don't sign, by the way? So for those reasons, I just tend to think it's not a good idea. Though, like I said, I'm two things. One is putting something in the enrollment agreement. If you don't have it already, it's certainly good. I also, by the way, I really do believe in communicating with families. So it is possible to have some kind of assumption of risk claim. If you send something to families saying, hey, families, listen, we're excited to see you. Here's all the things we're going to do in the fall to keep kids safe, to comply with the rules. And then, you know, people send their kids, there's an argument, I think a good argument, that as long as you're doing what you said you would do and what you're required to do, you would not be liable, at least not in terms of a negligence claim. Okay. Okay, I see another question just popped up. I'll answer it really quickly about employees. You know, it's generally the same thing, although with an employee, I think they'd be covered by workers' comp if they came to school and got sick with COVID-19. Though, again, if you were grossly negligent, there may be other claims as well. I mean, maybe I'm misreading the question because COVID-19 could raise Americans with Disabilities Act, reasonable accommodation issues. You know, people are afraid to come back even though it's safe. Again, I know that we could spend a long, long time talking about it. It's important. I don't mean to be dismissive of it, but it's 12:42, and I promised we would talk about things other than this. So I want to move on, but welcome questions about this later. I'm going to talk briefly about a number of issues. So SB 778 has to do with harassment training. We wanted to raise this issue because there was some confusion, and the legislature actually had to step in about training and when it was required. And the law really clarifies that schools now, this year, need to meet the requirements of 2 hours of sexual harassment training for supervisors and 1 hour of training for non-supervisors. There was a sense before that maybe it needed to happen last year, but it can be this year. There's a ministerial exception case that is directly relevant for religious schools, but it's a fascinating case, and I think is something everyone should take some interest in. I won't speak a lot about it, but the ministerial exception, if you're not familiar with that, it's a First Amendment issue. So it's one of the few times, really, that the First Amendment is relevant for private school cases. It's also relevant, by the way, if you don't know, we've talked about this before, another fascinating area of the law, is it's relevant for student free speech, for junior and high schools, but not employee or younger students. But that's a topic for another time. So the ministerial exception, part of the First Amendment says that Congress basically won't create any law establishing religion or prohibiting the free exercise of religion. Sorry, I got muted there for a second. Michelle didn't like what I was saying. What the First Amendment says is, really that the government can't tell a religious school who to employ, who not to employ in a religious role, which I think makes sense. If you think about it for a second, there are religious schools that restrict certain positions to men, such as priests, Orthodox rabbis can only be men, things like that. And in this case, there was a teacher who did not get her contract renewed, brought a claim for disability discrimination. The school said, you can't sue us for disability discrimination, you're a teacher. And at our school, we consider teachers to be ministers. And this case has now gone all the way up to the US Supreme Court. There was actually another very similar case that went up to the US Supreme Court too, but now it's going back. For those of you interested in litigation and the Ninth Circuit, you may not be surprised to hear that the Ninth Circuit, unlike every other circuit across the country, decided that this teacher or a teacher who taught religion a little bit could not be a minister. I think the expectation is the US Supreme Court is going to overturn this decision. I know that it's really can rub people the wrong way, but I do think that respecting, by the way, the way I'm framing it, you might not like either, but respecting freedom of religion, ensuring that the government is not getting involved in telling religious schools who need to be the messengers of the faith, the leaders of the school, is a really important issue in many ways. And it'll be interesting, I think, to see how the court decides. If anybody is interested, I may be the only one on this call, in listening to the oral argument. For the first time, it's going to be available live by phone on Wednesday at, I think, 9 a.m. our time, maybe 10 a.m. our time. But that's the case to watch, very important case for religious schools. This next case is a really important case for all schools. And I'm going to just summarize it because I know we're running short on time, and I want to make sure Donna in particular has time to talk about some cases. Here are the facts very basically. There was a student at a preschool who had diabetes, and the parents said, school, we want you to monitor our child's diabetes by having the child wear like a beacon, which could attach to the child's belt, and then keeping an iPhone within 20 feet of the child so that if the child's blood sugar goes low, you get an alarm, you give the kid juice. And the school said, we're not going to do it. And I don't know exactly why they decided not to do it, but they decided not to do it. And what happened? The Department of Justice came knocking on their door and said, hey, preschool, you're violating, I almost did that with a Southern accent for some reason, I don't know why. You're violating the Americans with Disabilities Act and forced the preschool to enter into a consent decree. And I'll tell you something, and I know Donna will back me up on this. Every year, there's cases like this. Every year, there are schools that for one reason or another, maybe they're unaware of the rules, maybe they don't, maybe they think these parents are difficult, we don't want to have to get involved, maybe they just think we can't do it. Every year we get cases where there are schools that say we're just not going to accommodate a child. And the Department of Justice takes these very seriously. So I wanted to mention two things that come up a lot in this context. One are applications. You should not be asking if a student has a disability on an application. That's a violation of the Americans with Disabilities Act, and yet I see that a lot. I get questions all the time, and I love the questions. The questions are, well, okay, we can't ask if they have a disability. Can we ask if they have? No, generally you can't. No. Generally, then schools get mad at me and they say, well, wait a minute, you know, it's not going to be good if we have a student at the school with a disability we can't accommodate. That's true. So figuring out how to raise those issues, how to talk to the families, that's important. But I got to tell you, you should not be asking on the application. The second thing that I don't want to be overlooked is that the process is very important. The sense I got from this consent decree was a preschool did not engage the family in a good faith, what's called interactive process, to talk about whether the child could be accommodated. Disability law is a highly litigated area of the law. It's not an area of the law that I think is particularly intuitive. And so if you find yourself dealing with this kind of issue, I really think it's important to kind of slow down, think about what you need to do, what's required of you, make sure you're meeting your obligations along the way, because typically the plaintiffs in these cases, whether it's a student or an employee, tend to be very sympathetic. And so you're going to want to make sure you're handling this the right way.
And Michael, could I make a quick comment on this?
Yeah.
I mean, I think that just from some of the cases we've dealt with, you know, when things don't go well and a student is leaving the school, the parents often ask for all the student records, and they make broad student records requests. And I would, in my experience, parents of disabled students who aren't doing well in the school are amazing advocates for their kids, and sometimes really difficult for our schools to deal with. Sometimes these parents are cross the line into rude behavior or attacking, you know, your teachers or marching onto campus. You know, we see this, and we see teachers sending emails to each other or sending emails to the head of school. And sometimes the way that those emails look in retrospect are not a good record for your school. And so we've been very disappointed to see what these subpoenas sometimes or requests, the requests sometimes from the family's attorneys dig up. So you always want to be on top of your records. What records do you need to keep? How long do you need to keep them? Because you know, with the electronic storage these days, it's really disappointing sometimes to see what gets dug up. And this is the area where I see it happen a lot.
That is such a great point, Donna. Thank you so much for raising that. You're so right. That's so important. And by the way, just to add one thing very quickly to that, that's the kind of thing that I think teachers, particularly who've not been trained in things like documentation and what can be discovered, they will often create those kinds of emails that will come back and haunt the school later out of frustration, and understandable frustration. But it can really make a school look bad. So thank you, Donna. That's so important. Okay, I'm going to mention a couple of other cases very quickly before turning it back to Donna. Also on the disability front, websites need to be ADA compliant, and we included this. I mean, it's a very interesting, important case on its own merits, but I think also in this world where so much is happening online, it's even more important. This case, by the way, kind of an interesting case. There was a woman named Cheryl Thurston who was blind and wanted to make a reservation or view a menu or both at a restaurant called the Whisper Lounge. Never heard of the Whisper Lounge. I'm not sure I'd want to eat at a restaurant called the Whisper Lounge, but she did. And she had something on her computer that would read the text of a website, and it wouldn't work on the Whisper Lounge website for some reason, and she sued. And the case was really interesting. And first of all, we mentioned the ADA Title III in the slide. I want you to also know, though, that she sued as well under something called the UNRU Civil Rights Act. It's a California statute specifically that prohibits discrimination. there was a very interesting discussion during the case as to whether things like websites were actually covered under the ADA and the Unruh Civil Rights Act. And the reason there was a question about it is because these laws were created before there were websites. And so the position was, how could this possibly be covered? This could not have been contemplated. But the courts, and again, I don't think it's surprising. People can certainly disagree with me on this and anything else you like to disagree with me on. But the court said no. I mean, websites are covered by the law. There is an obligation to reasonably accommodate people by having websites that will work with these kinds of software for reading and other things. And you need to do that. By the way, there's been a lot of criticism, not so much of the case itself, but of these particular kinds of claims, because maybe you've heard of this. There have been some law firms which do what's called, it's a pejorative term, but it's called drive-by litigation, where they will just check thousands of websites and send lawsuits against all kinds of employers claiming a violation. We've represented some schools in that. We've been able to get those dismissed. I don't take lightly at all the Americans with Disabilities Act or Unruh. I think it's important to accommodate those with disabilities, but there have also been claims of attorneys taking advantage of these laws just to try to kind of shake down employers. Okay, I'm going to just quickly mention a new law this year has to do with lactation accommodation. The California and federal law has required lactation accommodation for a long time. To be quite honest, when this bill passed, I sort of thought to myself, oh, okay, you know, we already have these laws. Here's a little more detail to it. But I have found over the last year that schools have been really concerned and had a lot of questions about these requirements. And the law does have many more specific requirements, such as that the lactation room has to be in close proximity to the person. What does that mean? And what if we have multiple buildings, even multiple campuses? And there's just not a lot of guidance on those kinds of issues yet. There's also, by the way, requirements about what has to go in your policy now regarding lactation in terms of giving notice and making sure people understand they have a right to raise issues about it and things like that. So if you're not familiar with it, let me know. Okay, I've gotten a couple of questions. I'll just very quickly, very quickly, only because Jessica's my neighbor, I will take this question and try to answer very quickly. So first of all, how is restroom defined, which was not Jessica? I don't know exactly how it's defined. I could look into that, or you could call, I don't know. I have an idea, I think is, you know, I think sort of what I would consider what you normally find in a restroom would define what's a restroom, but I could be wrong about that. I'll just read to you very quickly the certain features that it said. One is that the lactation room, not only does it have to be in close proximity to the employee's workspace, it has to be shielded from view and intrusion. And by the way, it's the and intrusion that I would get a lot of questions about, especially if there's preschools and young kids and things like that. There has to be a surface for the woman to be able to put down items. There has to be a place to sit. And there has to be access to electricity. There also, by the way, has to be a sink and a refrigerator. I don't think it has to be in the room itself, but there must be access to that. For the policy, I will just tell you very briefly that the policy has to note there's a right to an accommodation for a lactation room. There has to be a process for making a request to use the room. There has to be notice of the employee obligation to respond to a request, and you have to give notice of a right to file a claim with the labor commissioner if you think the school is not meeting its requirements. So I know I went through that quickly. If people have questions, feel free to email that in, ask for it again, or ask questions or anything you like based on that. But I'm gonna turn it over to Donna to discuss email systems.
So I have 3 quick cases I'm going to go through that are out of the National Labor Relations Board. Many of you will recall we had a series of cases from the National Labor Relations Board that were requiring us to change handbook language and were not favorable for employers. After the Trump administration took over, there were still Obama folks that were on the National Labor Relations Board, and there were vacancies. And so we still had some decisions from those folks that had been appointed in the Obama years. That has changed now. There are still 2 vacancies, but there are now 3 Republican appointees on the board that were appointed by the Trump administration, and they are rolling back some of these decisions. So 2 of these 3 are a rollback. So this first one on employer email systems is a rollback. It was just in, I think 2014 that the Purple Communications case came out, which found that employees did have a right to use employers' equipment, including the email system, for non-work purposes. And this was to allow them to be able to communicate with each other easily if they had concerns about their working conditions or workplace. That case was overruled by the Caesars case. And so the status of the law on that today is that you do not violate the National Labor Relations Act by restricting non-business use of your IT resources. Just very quickly, the point I would make on this is that you can't discriminate and allow some people to send out non-work related emails and then shut down a union, for example, or employees trying to unionize and reach out. So it creates other types of risks for you if you don't have it be very clean. If people are sending out birthday party notices and things like that that are not work related, your ability to hold the line with employees organizing or complaining, really goes away at that point. So, and then the next slide on employee social media activity. In this case,
I lost Donna. Am I the only one who can't hear Donna?
Oh, can you guys hear me?
Now I can.
Uh-oh. Okay.
The slides, apparently, I got the slides again.
Okay. So when people started calling in sick when they received the less desirable assignments, and so the company stopped telling people what their assignments were before they showed up for work. So some of the employees were complaining on Facebook, private Facebook, about this. And one of the employees was had a friend in management who was a Facebook friend, and the Facebook friend turned it over to other managers, and this person was fired for violating the unlawful conduct rule that the company had. And the National Labor Relations Board said, no, these posts were clearly protected concerted activities because the point of the posts was the ongoing collective communication about company policies and working conditions. So that was a case that went in favor of the employees. And then the last one is turning back to an earlier case. A few years ago, there was the National Labor Relations Board case that held that that employees, you could not prohibit employees from communicating with each other during workplace disciplinary investigations. And that was a tough rule for us to comply with in developing and modifying the handbook language around confidentiality provisions. And we've kind of, had to, dance around how we worded those over the last few years. Well, that has been overturned, and this overturned that 2015 Banner Healthcare Systems case. And so this recent decision rolls back the standard to what was called the Boeing test from 2007. And that requires looking at a rule and determining, is it likely to interfere with an employee's right to complain about you, essentially? And if the answer is no, and in this case, because this rule required that investigations, that confidentiality applied during the duration of the investigation, it wasn't forever, they found that rule was fine. If there is a question about whether a rule is okay, then you go into a legitimate business justification balancing test. So we are getting a series of cases every year from the National Labor Relations Board that mostly apply to how we update our handbooks and deal with issues of social media complaining, employees complaining about employers using social media. That's it on those. Any questions?
Thanks, Donna. I messed up the slides while you were speaking. I apologize to everyone for that. If you have questions about the slides and couldn't see it, let me know. I know we're past one. The last couple of things that I'm going to mention, I'll just mention very quickly. Immunizations have been a big deal even before COVID-19. And the legislature's been struggling, I would say, with trying to add to the laws that went into effect a couple of years ago to provide more clarity over process. And it's passed laws to do that. There will be forms that you can get and require and things like that. They really start taking effect in 2021. And then the last substantive slide has to do with negligence and liability. It's an older case. You can see it's 2018. Donna and I wanted to include it because it's just such an important issue that keeps coming up in one way or another. The case itself was basically one where a coach on his own was working with students and parents to organize allow the students to compete in a cross-country meet. It wasn't officially sanctioned by the school, and yet they had an employee who was really working on it. And tragically, in this case, the student was driving others to this cross-country meet, and there was an accident and somebody in the other car died. And the question was whether the school could be liable. And the answer is that the court found that potentially the school could be liable. So it's really important for schools to think through questions of liability, of negligence, of control over employees, and things like that. Because when you have, for example, if you ask employees to drive students, that can raise issues. If you are asking students to drive other students, that can raise these kinds of issues. So I think it's important to think about that. Okay, that is it. I know we went over, I'm sorry. Michelle.
Can I just answer one quick question though, a question about whether we see mandatory vaccination legislation coming with COVID vaccinations and things of that nature. And, I think the answer to that is likely yes. And I think we will see pushback from parents because these will be new vaccinations, which, even the old vaccinations make some people nervous. But, given the exigencies of the emergency, it would not surprise me. And that's, we'll be watching for that.
Thank you, Donna. If you have other questions, Donna and I are happy to answer them. You can follow up with us separately. Whatever you like.
Do we have any other questions? I know everybody's probably hungry right now.
Well, thank you for having us.
Yeah,
we
thank
always
you.
enjoy this conference.
Yeah, thank you, Donna and Michael. as always, we never have enough time to hear all the great things you guys have to say, or not so great things.
Exactly.
And just so everybody knows, the whole conference will be is recorded and will be available probably in the next week or so on the Cal-ISBOA site. Martha can probably fill you all in on that. But thank you all for helping us make this a successful conference. We had to pivot pretty quickly, and we're just so thankful that we're able to keep all this great information coming to you all.
Thank you, everybody, very much. Also, a reminder that if you're so inclined, we're having a virtual happy hour from 4:30 to 5:30, hosted by Armanino, and there will be a bartender demo. So the registration's available on the website or in the chat. You can still do that, and you just need to register to get the link. Thank you, Donna and Michael. It's so nice to see you. It's been so long.
Yeah.
Well, thank you.
And
You've done a job with this conference. I'm very impressed.
well, we appreciate all of your support and the support of all of our presenters and our sponsors and our membership, because this truly is an extraordinary time. So we appreciate it.
Very well.
All right, we'll take everybody. Stay safe out there.
You too.